Good morning. Welcome to Lesson 10 of the Judicial Branch. We are at our last lesson in Article 3 of the Constitution dealing with the Judicial Branch. And so we are going to finish up talking about the judges today with the Supreme Court. And then we will spend a couple of days reviewing. And then after we do the review, then you'll be taking your tests. Just keep in mind, you want to go back to the review questions that are posted for each of the weeks. Those should be put in your student resource section in your Google Classroom. And you'll be able to review the questions that are going to be important for the test. So, like I said, this is Lesson 10, so let's get right down to it. The judges of the court, we're talking about the judges of the Supreme Court, or what we call federal judges. And you'll notice here how many federal judges there are. 632 in the district courts, of course the 9 on the Supreme Court, and then 179 circuit judges, and then you have a whole bunch of other level of judges throughout in the legislative courts. And so it's important to keep in mind that these all are appointed by the president, or actually come out of the executive office as a request to Congress, because it will be, or each person has to be confirmed by the Senate. Now, there are some selection criteria, and that's what we're going to look at next, is the selection criteria. Okay? And these are things to keep in mind, and the most obvious is a law degree and that they've actually practiced law. If they're going to sit as a judge, they need to have started on the bottom rung and worked their way up so they understand the process, the entire system. Now, it's very important for us to acknowledge the fact that in the Constitution itself, for federal judges or any of the judges there are no qualifications listed such as this. Because it was very hard for people to get law degrees back then, so they left that kind of ambiguous or open for the future. Now you need to have a law degree. You need to have taken the time to study the law and to practice law. Previous positions in law and government, different areas. Like if you're going to be a judge dealing with taxes, then you need to have served as a lawyer in the tax system. If you're going to do one dealing with constitutional law, then you have been a lawyer in a constitutional law firm dealing with cases. Like when we went to visit Ben Sisney in Jay Sekulo's office. He has a background in doing constitutional law, and that's how he got the job there. So previous positions and dealing in the law that you're actually going to become a judge in. High administrative or judicial positions. With this, it means that you have served at this level or had that kind of responsibility and have proven yourself capable in those areas. Selection criteria also deals with party affiliation. So this is an interesting fact. And this is why presidential elections, when you have one of the justices on the Supreme Court's positions becoming available, that who's the president, because usually 90% of the appointees have come from the president's party. And so that gets to the next criteria, is political ideology. So are they a moderate, conservative, liberal? Based on some of the issues that are going to be coming from the court, you want to have people with particular political ideology, so that you know some of those things are voted on favorably according to the president's ideology. All right, so that's one of the reasons why presidential elections are so important when justices are coming up or their seats are becoming available. Race or gender, one of the things that they're trying to do is make sure there is a broad spectrum. Just like we want on a jury, you want a cross section of your community. Well, same here with race and gender. They want a cross section in the federal judges, so they're trying to keep that as close as possible in race and gender representation. The senatorial courtesy basically deals with some of the federal judges sit in, like each one, like we have the District Court of Hawaii. So the senators from the state of Hawaii get to acknowledge or send in recommendations to the president of who will sit on that as judge in that circuit or that district. And so that's what the senatorial courtesy, they will listen to the representation from the Senate saying we want this seat to be filled by this person in our district. and then the president can listen to that or not listen to it, and then they go on to senatorial confirmation after that. Okay, so ideas from choices, where do you get these? First of all, Congress, suggestions from senators of the states, like I was just mentioning, where vacancies exist. Executive branch agencies. So the president has people working to find legitimate candidates for seats that are becoming available in judgeships. And those come out of the executive office and they are shared with the president, and then the president reviews those with his executive council, and then they determine if those are legitimate candidates or people who will support the type of political ideology that they have. So there's a whole group of people that work for the president helping him appoint these different people. Judicial recommendations. So a judge who is leaving a seat can recommend someone to replace him, or same thing out of the Supreme Court. The Supreme Court goes, we like this candidate. This is somebody that we need to help us get through some of the things that we want to do. And so that's judicial recommendation. Self-promotion, a person could say, hey, I want to be a judge. And so they kind of promote themselves. They write up their own resume and they kind of toot their own horn, so to speak, with their own portfolios. And then this is one that is really interesting, okay, with the American Bar Association, because you have to have a legal license to practice law from the American Bar Association, and that's what they mean being disbarred. You've been kicked out of the Bar Association, and they give performance rankings, and this is based on your trials, the cases that you have done, feedback from other people about how you handle yourself. So you can get rankings as well qualified. This person is well qualified. They can do any job that you put them into, or they'd be well qualified as a judge or not qualified. And that's based on your Bar Association ranking. So when these different people make these recommendations, the first thing that they do is they go to the American Bar Association. They make sure your ranking's high enough so they don't look like a fool when they recommend you. Okay? Moving on, court at work. Okay, next section. Sorry, we're moving a little fast today. Court's annual term runs from the first Monday of October through the month of June. So the first Monday of October, and then it goes all the way till June. So when we were there in March, when we go on the historical trip, we visit the Supreme Court, they're actually hearing cases. Okay? Reason cases are chosen. All right? The legal question has been decided differently by two lower courts. So you have a court here and a court here, and they have decided differently. Then the Supreme Court must determine which one was correct. When a lower court decision conflicts with an existing Supreme Court ruling, so they came out with a ruling, a decision on a case, and it's different than what the Supreme Court, as far as precedent said, had done in the past. So the Supreme Court said this, the lower court said this. It's different, so the Supreme Court will take this case and they will determine if their decision was right in the past or if this new decision has a better understanding or more in-depth interpretation of the law. Okay, next one, when the ramifications could reach far beyond two parties involved. So if this decision is effected here, it could be used as precedent later on, and it's going to have a broader reach and a broader spectrum in the future. Okay, and then what they have, another ruling is they have the rule of four. So if four of the justices on the Supreme Court want to handle a case, want to review a case, then that case will be brought in. But it has to be at least four. That's not a majority, okay? It's one below a majority, but it's enough to say this is important. So it's called the rule of four. And then hearing and deciding, this is the last section that we're talking about today. They will hear 2 to 3 cases Monday through Wednesday. And when we went to the Supreme Court, the video that they watch, one of the things that you have to understand is when they hear these cases, they're only hearing like a 30 to 40 minute blip from a lawyer about this side and about this side. And that's all they get. That's all they hear. And then what happens is they have already done all their research. They have read all the materials, all the evidence that was provided by the two sides. And then this is like their big time to get in and maybe sway the judge one way or another. The judges on the Supreme Court. But basically, they pretty much have their minds made up when they go in to hear these two sides in these 30 to 40 minute little speeches that they give. Okay, the justices review the briefs before the hearings and the arguments of the lawyers, what I just said, and then they have private counsels before and after. Most of the time it's before they hear the arguments to kind of ask questions, get feedback, and that's the time, not in the courtroom, but in these preliminary hearings and everything in the judges' chambers or in their room that they get to meet, which we saw a video of when we were at the Supreme Court. Simple majority decides, so 5-4 decision can win. Okay, and this is an interesting fact that 1/3 of all the cases that come through the Supreme Court are decided unanimously. That's 9-4 and 0 against, or 0-4 and 9 against. Okay, so that's a pretty interesting fact right there. And then these we've already discussed in some of the terms that you did in the beginning, but the majority of the opinion is the official opinion of the court and read by the writer at a public session. So remember, 5 votes for, 4 against, the majority opinion wins, the 5. So the senior justice on the majority side writes the opinion. And then that writer reads it at a public session as in favor of. Okay? But there's also 2 other, the dissenting opinion. So they always choose one from the other side to write the dissenting opinion. And then if one of the 5 that won in the first place or the 6 that won in the first place, if they have an opinion, what they call a concurring opinion, yes, we agree this should pass, and we agree with the majority opinion, but here's another reason why it should have passed. And that's what the concurring opinion is written for. Okay? So this concludes our discussion of the Supreme Court, the judges, how the court is basically run, and then hearing and deciding cases. This is a very, putting it into a nutshell, very simple and concise. So anyway, use this to do your review questions for this section once you watch the video. And this concludes Article 3 of the Constitution. And after this, we'll move on to the economy of the United States. And we're also going to look at God's economy. All right, the Lord bless you. Have a great day. We'll see you next time. Adios.